All right, good afternoon. I'm going to go ahead and get started. First bill, I'm just going to go down the agenda today. So Representative David Clark, HB 319. I think you're on.
Is it on? Hello? Yep. Perfect.
Hello.
Thank you, Madam Chair, and House members on the committee. I bring today House Bill 319, LC 481513S. Should be the subcommittee that you have. House Bill 319 is aimed at enforcing immigration law and regulations. As recently seen in New Jersey with Governor Phil Murphy, state officials and across this country, state officials are obstructing federal and state immigration law. This bill essentially creates a mandated reporting statute for all local and state government officials harboring, concealing, or aiding and abetting a criminal illegal alien. State or local officials elected, appointed, or hired are required to comply with this act, including the governor. Furthermore, this bill authorizes Georgia prosecutors to charge officials that harbor, conceal, or abet an illegal alien. Lastly, this bill authorizes the governor to use removal powers to remove rogue officials violating this code section. As state and local officials, we take an oath to the United States Constitution as well as the state constitution, per Georgia Code section 45-3-1. We also promise to protect, defend, and uphold the laws of the state and federal government. Even as state legislators, many of us disagree with several laws on the book. Hence is why we run for the legislature. Even as legislators, we are required to protect, defend, and uphold the laws of the state that we do not agree with and disagree with. If we pick and choose what laws we make as state employees, if we pick and choose what laws we make, state employees, and that employees follow, then what is the whole point of this? What is the point of our legislating? After speaking with stakeholders, I have worked to draft this legislation so that there is a clear intention, both legislatively and for the offender to be convicted. We have provided exceptions for law enforcement, judicial officers, federal officers, and those assisting an illegal alien in getting to get to a judicial government proceeding. Additionally, we took steps to ensure applying for non-immigrant S visas for witnesses and confidential informants is also shielded. This is a common sense law, I believe, that ensures our state is putting resources towards Georgians. As public officials, once again, we take an oath of office, and if you have a problem upholding that oath, then I believe you should resign. You're not here for what you ran for, and you need to set it aside for a special election, I believe, because I know myself, whether it be in the military, I've served many years, or as an elected, you raise your right hand, and as an elected official here in Georgia, you're raising an oath to the state constitution and the federal constitution, and I take that very serious, and I believe, as we're seeing across this nation, people trying to sidestep laws they don't like, and if you don't like it, then that's why you run for the legislature. You drop a bill, and you get across through the House, the Senate, and to the governor's desk. So with that, we're glad to take any questions on House Bill 319.
Thank you, Representative. You do have one question. Is that Representative Panish?
I have like 3 or 4, but I'll start with one. Hey, thank you. Isn't this already a violation of oath? Isn't that already a prosecutable crime if a public official who takes an oath violates their oath?
I mean, according to law, to abetting and knowingly and willingly
Those
doing
are all
this.
crimes too. Abetting, accessory, those are all already crimes. What does this add that isn't already a crime?
This is putting more teeth into it, and also allowing the governor to remove them, whether it be elected or an employee.
So that brings me to my next question. Well, is there a definition of illegal alien in Georgia Code? I'm not aware of one,
I can't
so
say
I don't know.
off the top of my head, but I mean, if you I mean, I would say if you come across the border, you know,
Well, that's a civil
yeah.
violation. Well,
Yeah.
coming across the border might be a criminal violation, but being here or overstaying your stay may be a civil violation. So I don't know what counts as illegal alien because I don't know that it's defined in Georgia law. I think it needs to be defined if you're going to put this in here. Then my other question, there was a movement a few years ago talking about what would happen if the governor or federal official banned certain weapons. And if that became law, you know, this bill could be used to, or an extension of this bill, if sheriffs don't want to enforce that kind of law by taking people's weapons away, now you're criminalizing. I mean, do you realize that this can go both ways? You might want it for illegal aliens, whatever that is, but it can also be applied to any law that's not being enforced because of the discretion of the prosecutors.
Representative, I'm not really, I didn't follow that last question. Are you talking about a law that we don't have in place that this
I'm
may
saying if there's
go
a
against?
law in place. There were years ago, there was discussion of having a law that had, I mean, obviously it wouldn't have been from our state, but it would have been a federal law about banning certain weapons. And there were sheriffs who came out and said, we're not going to enforce that law if it passes. So to me, this is just like that's the next step. And we can be ready to enforce that. But there is a definition of illegal alien, sorry.
Yes, I believe it's code section 1611-202 is a definition of illegal alien, so we already have it.
So, if you want me to just share it so the author knows, I can.
Do you need us to define it? It is in,
Yeah.
we do have a definition,
Okay.
so I think that was the question.
Thank you.
Thank you. Any other questions from members of the committee? I don't see any, but I do have one person signed up to
Yeah,
speak.
I was wondering, I mean, I mentioned
Sure.
the gun hypothetical, which you hear a lot, is, I mean, sheriffs don't have to enforce unconstitutional laws, and I think, well, I mean, just like technically if somebody wants to sue any law, they can, but there's also the Constitution that we have, and that's what protects certain rights. So I know you bring that gun question up, but I don't see that this bill lines up with that type of hypothetical.
All right, I'm going to call up the one person signed up, representative.
Yep.
Jennifer Lee. You can sit, yes. David, do you want to scoot a little
Yep.
bit? And there's a mic on the other side if you want to. If you can say your name and the organization you're with, and then you
Sure.
may proceed.
Okay. My name is Jennifer Lee, and I'm the policy director at a nonprofit legal advocacy organization called Asian Americans Advancing Justice Atlanta, which is dedicated to protecting the civil rights of Asian Americans and Pacific Islanders in Georgia. We also provide a variety of immigration legal services to clients at low or no cost. I recognize that the aim of this bill is to enforce compliance with state law. And I also recognize that there is a balance that we need to hold with holding both local officials and employees accountable for harm and for breaking the law, and protecting the efficient provision of essential government functions and services. In my mind, that means that government entities and their officials need to be able to perform their duties effectively without like undue fear of prosecution or litigation. And amid our complex web of federal, state, and local laws and policies, local officials and employees are often needing to use their individual discretion in what may be complex situations involving immigration enforcement or knowledge of someone's immigration status. I bring this up just because, in addition to law enforcement, which you named as being an exception in this bill, local governments do play a lot of important community functions. including fire, in some cases, in parks programs, in some cases, health services, public transportation, libraries. And I fear that a consequence of this law would be that there's an interpretation of this law that is based on fear that would strain community relations and people being able to make the judgments that they want to, that they need to in providing the services they do as in local governments. And that one of the consequences would also be sort of an over-enforcement or overzealous enforcement in trying to avoid the penalties in this law. I work with communities that have expressed a lot of fear and confusion, not only because they feel like they might be affected by immigration enforcement, but frankly just because, for example, I had a conversation with someone working at a school confused about what might come up with them if they were questioned about a family or were somehow entangled with immigration enforcement, what their rights and responsibilities would be in balancing their duties as an educator and also complying with state law. I also want to note that although there is, a definition of illegal alien in code, we are living in a time right now where there is a lot of instability in federal immigration law and immigration statuses. So we have seen that there are programs where individuals who, for example, were seeking asylum or even who had work authorization through federal government programs have seen those programs canceled. And so they actually did have work authorization and some sort of legal status, and they are now undocumented because the programs and procedures that they were following have recently been changed or their programs were canceled, and we have seen those individuals be vulnerable to immigration enforcement. So just to say that I think the situation right now is very unstable and things are sort of shaking themselves out. And so with that in mind, I'm not sure that it would be wise to take this sort of approach to this law to enforce compliance with state law, to take this type of punitive approach while those things are also up in the air. So thank you for your time.
Thank you. Any questions from members? I don't see any. Thank you so much. Representative Clark, if you have any more to say, we're going to keep this hearing only today.
Yeah, I was going to say, I don't think this has anything to do with prosecutorial discretion. This has to do with people violating the law and aiding a criminal, which is, it says that in my substitute. We arrest American citizens for this daily. And educators was brought up, they cannot give immigration advice. That's violation of, I think it's Title 10, Chapter 12, or it's Title 12, Chapter 10, which bars judicial and executive branch employees from providing legal advice. So just going to clarify that. But I think what this is doing, it says in the bill, it says, who's convicted of directly or intentionally causing, advising, encouraging, or counseling an employee or subordinate to conceal or harbor an illegal alien. I think it goes straight to the heart of, which we know a nation that has no border. It's not a nation. We need to have control over that, and I think we know it's happening, and I know it's happening here. I've talked to multiple people of this happening, sidestepping the law, and myself, I don't bring this out of fear or a stigma. That's not how I operate. I've served in the special operations. A lot of it also it's about looking at a community, making sure it's safe, secure, and then also the rule of law is the rule of law, and I think we need to get back to that, and we're seeing that being sidestepped daily. But thank you for hearing this bill.
Representative Penich, I think she has one more question.
Yes. So I'm a criminal defense lawyer. Sometimes I'm hired, I'm not appointed. And this only excludes public defenders from counseling clients. Did you intend to exclude private lawyers, or would you be open, assuming this moves forward, would you be open to any member of the state bar?
We could talk.
Okay.
I'm open if that makes sense.
Thank you.
All right, thank you. Thank you, Representative. All right, next bill. Yeah. Representative Dempsey. Yes. House Bill 533. Good morning. And you have,
Is it good?
All good for the house, right? That's good. It's a good time for it. Yeah, for sure.
both mics are on and you may proceed.
Thank you so much. Thank you, Chairman and members of the committee. I know you're all really very familiar with this piece of legislation. It's been worked on for many years, especially by Representative Holcomb, and I am just thrilled to be working with him for us to be a team and try to tackle this really challenging effort. The Wrongful Compensation Act, HB 533, it establishes a statutory process for fairly and uniformly compensating innocent people who were incarcerated for crimes that they did not commit. Innocence is the main word in that right there. I'm going to talk just a little bit about what it's like in the House right now, and then let Representative Holcomb take you through the bill, and through questions you may have, we'll answer together. But this is done through the appropriations process. Begins in the House. Well, it actually begins in the Secretary of State's office, where they have to be denied, is what happens. That is not the Secretary of State's role to say that, yes, you deserve that. So it's a denial process that then we bring to Appropriations Committee and try to get out. Historically, when Terry England was chairman of Appropriations, he would appoint several of us to serve. I did, I believe, 4 years at least listening to these. It's a very hard thing to sit and listen to. We're not equipped to do that as legislators. Some of you that are on this panel probably would be because of your legal experience. But we're dealing with holding someone's life in our hands, and that's not what we were elected to do. I do not think at that point. So I've sat on it 4 times, listened to a variety of really heart-wrenching and sad and difficult circumstances and situations. When Chairman Hatchett began to chair, he has worked it through committee there. So Marcus Wiedauer is the chairman of that committee right now, and he's doing a great job of listening to those, and those members are too. But there is still a better way for us to do it. And as Georgia sits today, one of only 11 states that do not have a better process for this, rather than turning it over to part-time elected legislators, it is time, I think, for us to step up, and we have a great opportunity. I feel very good about this bill. The many people that have worked on it, it has gone through the process of working with our House leadership, with many legal eyes putting their eyes upon it, and just been fully vetted. I think it's very improved and very good. So if it's okay with you, I'd like to let Representative Holcomb take you through it.
Okay. Thank you, Chairman Dempsey. It's been an absolute pleasure working on this with you. And the main goal that we're trying to achieve is to really implement a system of fairness, because right now the system is unfair. As some people get compensated, some do not, and then the amounts that are compensated are wildly random. And if you were to go back and look at what has been awarded, there is a striking lack of consistency across the board. So what we're trying to do is to put into place clear guidelines with guardrails to make sure that only people who are innocent will benefit from this. And with that, I'll start to walk you through. And if we begin on page 2, the major difference between the reform proposal that's been presented in prior years is, in prior years we had a commission. We've listened to a lot of experts, and they recommended that we shift to the Office of State Administrative Hearings for a judge. The primary reason for that was a concern that while the commission well-intentioned, things may not move because all of those people have other responsibilities, and we want this to move. We want there to be resources and attention directed towards it. So with that, one of the big shifts is away from a commission and towards an administrative law judge who will review this, and certainly the judge will have the training and expertise to be able to make the evaluation. Down at the bottom of page 2, the new 17-22-4 would set forth the process for filing a claim and the time periods. It would need to be filed within 3 years. If this were to pass and be signed by the governor, and it has within 3 years of July 1st of 2025, and then going forward for new cases, is they would also have a 3-year period from the time that they were exonerated. Under subparagraphs B and C, there are provisions whereby if within 2 years of being exonerated, an individual found new evidence, that would add an additional year to the tolling period. So you'd get a little bit more time to move forward. And the idea behind that is for a number of these individuals, it's not easy to get legal help and to get these moving. So we want to have enough time to allow them the opportunity to get counsel and to file a claim, but also have a time period that isn't unlimited. So that's the idea behind the statute of limitations periods. With respect to 17-22-5, which begins on line 55, this sets forth the rules and the process. And the main one that I'll point out for the committee is found on 63 and 64. And basically, that's that you have to prove innocence. It states the claimant did not commit the crime for which the claimant was convicted. It did not commit any lesser included offense. So it's very clear that this is for somebody who has to demonstrate by a preponderance of evidence that they, in fact, did not do it. The most likely way that this will happen is through DNA evidence, which the state has made a great investment in terms of DNA evidence, both in terms of testing and with respect to preserving. On the next page, top of page 4, procedurally, an individual also has to satisfy a number of just procedural hurdles, which those of you that practice in this area know that it's very difficult to get a case or charges reversed or vacated. After conviction, the deck is stacked against that person. So with that, those are just additional barriers and hurdles that a claimant would need to overcome. The bill also provides some safeguards in terms of excluding an individual, and those can be found in lines 84 to 88, meaning if the person was involved as an accomplice, you're not going to get compensated. And if you also are an individual for the purpose of protecting the true perpetrator from conviction pled, you also would not be allowed to be compensated. So there's provisions in here to make sure that only the truly innocent would be those that would benefit from it. Moving on to page 5, new code section 17-22-6. That sets forth the claims process, which would provide before the Office of State Administrative Hearings. Once a claim is made, an administrative judge will be designated within 15 days, and then we want this to move along. So within 180 days, there will be a hearing to consider the claimant's request. After that, the administrative judge will have to write up an opinion and explain why compensation is being recommended, and then this would go to the Chief Justice of the Supreme Court of Georgia. The way that we envision this, just to be very clear on the legislative intent, is that this would be primarily an administrative role. So the fact-finding and the judicial review would be done by the administrative law judge, and then it would be forwarded to the Chief Justice for input into the budget. But it's not really like an appellate review that you might think of in the court setting. The amount of the compensation, and this goes on to the top of page 6, would be for each year of incarceration $75,000, and it would be prorated if necessary. And then there would be an additional $25,000 if anyone was convicted with the death penalty, because those conditions are particularly grave. Those numbers were the product of some research, a review across the country in terms of where states are. And there is a fair amount of variety in terms of what states do. Some states only provide a dollar figure, which this is right within the range of the norm. Some do a lot more. Some provide free education. Some provide healthcare for life, et cetera. But this will definitely help those that have been wrongfully convicted. Let's see. In calculating the time, scrolling down to line 128, is that it would only be for the time served, and if there were an instance where a separate crime that the person actually committed was involved, then you do not get credit for that time. So that's another exclusionary provision with respect to how the compensation would be calculated. The payment can also be made to heirs. So if the person were to pass away, as this money would be something that could pass to that individual's family. And then moving on to, and that's at the top of page 7. And then with respect to this administrative process of the findings and the budgeting in 17-22-8, that's where it would be sent to the Chief Justice of the Supreme Court to then be putting to the budget. With that, I would like to share with the committee that in coordination with the courts, we did receive a request to make a slight addition. So if at the proper time, what would be requested would be on line 164. A clause to start that sentence that states subject to funds appropriated by the General Assembly. And the idea there is just they wouldn't want this to come out of their operating funds for just the operating of the courts themselves. So there would have to be a specific appropriation for these individuals. So they'd ask for that clause to be put in. And then the Chief Justice would put it into the Judiciary budget, and it would be considered by the Appropriations Committee, but that would be the venue by which that request would ultimately be made. And let's see, the final points to cover would be on page 8, 17-22-9. Similar to prior versions, is there's a carve out if there was a civil lawsuit, you don't get to double dip. So there would be a credit for any monies that might have been obtained through civil litigation for a wrongful conviction, and those would be credited towards any amount that might be awarded under this provision. And then I think a very helpful provision is added in 17-22-10, which begins on line 202 on page 9, and that's when there is an entry of dismissal or acquittal or through the pardons and paroles, they have to affirmatively give that person this chapter. So they have notice of their rights to potentially file a claim for exoneration. That then is filed as part of the record. So for tracking the statute of limitations, back in the section that we began with, this is how we'll track that and have it part of the record. And it should be very clear. And then on the final page, 28-5-87, that is the code section that provides for claims against the state or departments of agencies. So that's really clarifying language saying that this section or claims against the state for wrongful conviction will not go under that code section, but will rather go under this new provision. So hopefully that's helpful to the committee, and I'd be happy to answer any questions if there are any.
Thank you. That was very thorough and good, Bill. So let's see. Any questions? I do not see any questions. Anybody? I don't see anybody signed up for this one, but is anybody wanting to make a statement? Okay. Well, what's the... I did have a question. I'm pulling up the code section, and I'm sure this is how it's been done, but line 182, just regarding claimants, attorneys, and not being able to collect fees. Can you explain that part and the reasoning for it?
I think it's just on a contingency basis,
Okay.
so they can get the claims. I read that as an exclusion, as you just can't do this on a contingency basis, but you could do it hourly.
I see. Okay. All right. Representative Penish, do you have a question?
Just more of a comment.
Okay.
I just want to thank you both for bringing this in a bipartisan manner. I wish we saw one from each party on most issues here, because I think we agree on most things. But thank you very much for bringing it together.
Thank you.
All right. Thank you. What's the will of the committee? All right. I have a motion. Do I have a second? Second. All those in favor of passing House Bill. I'm sorry? Oh, yes. I guess I think we did this in Judiciary before. So did everybody understand Representative Holcomb's amendment? Any questions? Do we have a motion to pass that amendment?
I make the motion to pass the amendment described.
All
Want
right.
me to read it? I can.
And then a second. All right. All those in favor of passing Representative Holcomb's amendment, say aye.
Aye.
Opposed, say aye. All right, so that passes. And we have a motion and a second on the bill, House Bill 533, LC 600088. Any further discussion? All right, all those in favor of House Bill 533, say aye. Those opposed, same sign. All right, passes. Thank you. Congratulations. All right. Next is Representative Taylor. House Bill 421. Good afternoon.
Good afternoon, Chairman.
You may proceed whenever you're ready.
Okay, thank you. Yes, today I'm bringing you House Bill 421. And this is a bill that's been in several different forms for a number of years. And what it does, it is...
And on that note, we have LC 481448.
Let me make sure I've got the right copy here.
Yes, ma'am.
Yes, 1448.
Okay.
I guess I'll start with the history of where this bill came from. Several years ago, a minor in Thomasville was approached online by a person from another state, and he traveled to Thomasville for indecent purposes with this child. And the father found out about it and stopped it, and it was never consummated. The police were called, they were arrested, and unfortunately, when it went to trial, the judge threw it out and said, we did not have a statute or a bill that addressed this issue. And as I said, this bill has been in several forms, and I think last year Representative Reeves put this together. He has streamlined it. It is very succinct. It comes right out and says that a person that is traveling to meet with a child for indecent purposes from out of state, from any other state, or causes someone to try to pervert a child, try to have sex with them, or a person that solicits, entices, or commits any act of child molestation or other indecent act can be charged with this, and it would be a felony. And it's ironic that today I just got the invitation for the indecent tour that's done every year up here, and I've been on that tour. And it is heartbreaking to see children that have been abused and are used in the sex trade. And part of it, as we know, Georgia has a target on it. We're a great state to do business, but we don't want that kind of business. And I think this is a way to protect children, and that's why I brought the bill. I'm sorry. I think it is something that we need to address, and there wasn't anything that could address this particular crime, and that's why I brought the bill.
Okay. We've got one question. Representative Panish.
Sorry. Hi, thank
Yes.
you to the author. This is clearly a heinous crime. It needs to be punished. My only concern is lines 21 to 24, which references line 16, is a punishment of 2 years to 10 years. But the statute right now in code gives it a 10-year to 30-year punishment. I assume you don't want it to be less
No, I
punishment
do
than
not
it
want
is
it to
now.
be less. I
Okay.
would be open to an amendment to have that.
Okay,
Thank you.
So I did think, I guess, so there's a code section 16-6-5.
That's what I'm referencing.
Is that what you did? Okay.
Yeah.
Do you know if there's anything different about your bill versus that code section? I don't know if you had a chance to look at that code
I
section.
haven't looked at that because I am not an attorney.
Sorry. I think maybe we'll look at that
Because
and see.
again, we're basing this on a judge just absolutely letting the person go, and they were not prosecuted. And although we can, and sometimes do challenge decisions that judges make, we were heartfelt in our community when this happened, and I would hate to see it happen to anyone else. And again, it was timely to get the invitation to this terrible tour and what is happening to children, and we need to do everything we can to protect them in the state of Georgia. Thank you.
Thank you. We have some people signed up, so I'm
Thank
going to
you.
start calling. Thank you, Representative. Maisie Lynn and Carlos Rodriguez.
I'll let Carlos take the seat.
I think they can. Chairman Smith, did you want to say something
I'm not
before
trying to
the
steal y'all's thunder. Is attempt not already a crime in the code?
Crimes can be charged. Go. You can answer, please.
And you're asking me, so.
Yes.
So, I can't speak to that one particular case that may have happened several years ago. Madam Chairwoman, good afternoon, members of the committee. My name is Carlos Rodriguez. I'm a criminal defense attorney here in Cobb County. I practice in the metro Atlanta area. I do handle complicated sex cases such as these, and while this statute may not have been in effect 3 years ago, the criminal attempt statute certainly was. Enticing a child for indecent purposes certainly was. And whether you're traveling over state lines or leaving the garage, getting in the car and traveling towards someone that is believed to be a child for indecent purposes, that's enticing. So respectfully, there's no need for this bill to be passed. You've got laws that sufficiently cover any substantial step taken with the intent of committing an act of child molestation. And in fact, we've got more than criminal attempt. So just by my quick look, 1612-100.2, that's the computer or electronic pornography child exploitation prevention, that statute. It actually makes it a little easier for the state to prove exactly what took place in Thomasville a few years ago. There, it's not an age limit of 16, it's anyone under the age of 18 or believed to be under the age of 18. And so that statute certainly could have been used. And so, again, I can't speak to the failure of the prosecution to decide which statute to indict. But it sounds like the judge did the right thing based on the prosecutor's decision and their discretion to use the laws that were available there. So thank you.
Thank you. And Mr. Rodriguez, I've known you for a long time, and great lawyer. Thank you for joining us today. So do you, and that is kind of what we're looking at. often I feel like in judiciary we see bills and we wonder, don't we already have this? And so that's one question is, do you see anything in Chairwoman Taylor's bill that we're not covering in our current statute?
No, I don't. I think the solicitation of sodomy, that covers solicitations for attempts to commit acts of sodomy with children under the age of 16. So, I mean, there are a number of statutes that honestly could have been used here.
You mentioned about how an attempt sentence is hatched.
Sure.
So that's why the sentencing is actually best laid out here.
That's right. And so the way that criminal attempt offenses are punished, it's half of the attempted offense. So enticing a child for indecent purposes, that I believe carries a 10 to 30, so 10-year mandatory minimum, 30 maximum. So if it were a criminal attempt to commit enticing a child for indecent purposes, that would be a 5 to 15. So just
Okay.
pointing out that distinction as well.
All right. You've got one question, Chairman Smith.
This is actually the author bill. You didn't happen to bring your DA with you today, did you?
No, I didn't, but I did bring somebody.
I know you got the sheriff here. Sheriff, we
Well, he
We
did-
do have a.
yeah, my sheriff couldn't get here today.
okay?
So he wants very much to have this bill.
Gotcha.
He happened to have been the investigator on it, and he's now our county sheriff. So he's been looking for this for 10 years.
Okay. Let me ask Gackel this. When was this case decided? What year?
I don't know.
I'm not
I'm
familiar
sorry.
with the case.
We
Okay.
also don't know the reason it was dismissed. There could
Yeah.
be many other reasons a case is dismissed beyond an artful prosecution. I mean, there could have been a suppression issue. There could have been other reasons why the judge was unable to, why a conviction wasn't reached. Because we don't know the facts, we don't know all of the circumstances around that dismissal, unfortunately.
Chairwoman Taylor, I'm interested in this case. We'll try to see if we can get our resources together to get a
Okay.
copy of those pleadings. That should be public record unless it was sealed.
That's fine. I do have, Representative Reese was going to be here. He helped on this bill. Is there anything you want to add?
Feel free. We always like a former member of our committee coming up.
Do you have nothing else for us?
No, I'm good.
Sure.
Thank you.
Thank
Thank
you.
you.
Thank you. And, yes, Representative Reeves.
Thank you, Chair. The now Sheriff of Thomas County, who was police chief in Thomasville at the time, had 3 ideas that were presented to this committee last term. This was the one that made it from this committee to rules. This is the version that was scrubbed and approved by this committee. We had worked with prosecutors, criminal defense lawyers, all parties involved last year, and the committee passed this version out to rules. The sheriff drew upon language from other states that have a specific law about a perpetrator crossing state lines with the intent to molest a child. Sodomy, of course, is a very specific crime, so I don't think that current sodomy, attempted sodomy statute covers, a child molestation effort like some of our neighboring states do, and like the sheriff has found out. Thomas County obviously shares a big border with Florida. We got numerous counties that share a border with Florida. We got Alabama, North Carolina, Tennessee, South Carolina. So having a good law in effect that gives tools to dissuade predators from coming into Georgia is what this bill is all about. I appreciate you hearing it again this year, and I'm glad to help on the legal research. I know that sheriff is an abundance of information, so I'm glad to work with Chair Lady Taylor to get the committee more information if more information is desired. But this version, though, got the thumbs up last time. So it was thoroughly aired out last time for 2 years and finally passed from this committee to rules.
Thank you. And I would like to look at that case law more and kind of compare all of the different statutes that we have in
Yes.
place and whether or not this is necessary. Does Pac or DA Cranford, do you want to come up and say anything? You don't have to, but it would be good to hear your side as well, if you do.
I don't know how informed my testimony will be. I could offer some thought.
Or maybe if you can if you can be in that conversation with us and try to see what we can do. Good. Thank you so much. Chairman Smith?
If he wasn't the DA when this case was decided, that's fair. I get
Yes. Thank you. So we'll just keep it a hearing only this afternoon, and then we'll continue
I
to
will
work
get
with you.
copies of that case, and with short notice to be able to get somebody from Thomasville up here. The sheriff is very much involved, and one of the other detectives still asks about the bill all the time.
Okay.
Specifically, we'll probably judge, if the judge,
He's retired now, but,
the order he issued
Okay.
dismissing the case.
okay,
Just, that's kind of what we're trying to get the crux of.
okay. I'll get it.
Thank you. Thank you, Madam
very
Chair.
much.
All right, next bill, Representative Seabaugh, HB 384.
Thank you, Madam Chair, Committee. I've got Lance LaRusso, he's General Counsel for the Fraternal Order of Police, and in case you have hard questions I can't answer about this bill, but I think it's a it's a fairly straightforward bill, and I'm operating off of it's House Bill 384 LC 560283. This bill will standardize the oath taken by all peace officers in Georgia, ensuring uniformity across different agencies. It also limits criminal prosecutions of peace officers and correctional officers under the violation of oath statute to only those oaths explicitly prescribed by state law. Any additional oaths taken beyond those outlined in this bill will be considered aspirational and will not carry the legal weight in criminal or civil proceedings. While this change could potentially shield officers from certain legal repercussions, it raises concerns about accountability. The financial implications of this bill are minimal, as it does not introduce new funding requirements or impose direct costs on taxpayers. So the pros of this bill are it standardizes the oath. It creates a uniform oath for all peace officers, ensuring consistency across different jurisdictions and reducing confusion. It has the support of all of our law enforcement agencies. Officers will not face criminal charges for violating aspirational portions of their oath, shielding them from politically or motivated or vague legal challenges. And it supports law enforcement morale by reducing the legal risk for officers related to ambiguous or overly broad oath violations. This bill may enhance officer retention and recruitment. And with that, I'll be happy to answer any questions.
Thank you, Representative. Thank you, Mr. Russo, for being here. I know you're an expert in this field, so Judge Gunner has a question.
Hi. Thank you for bringing the bill. Now, I'm just trying to understand. We're subjecting it only to violations for a felony. Is that right?
Yes.
Okay. Well, let's just say they committed a misdemeanor, violating an oath under the old law. How does the folks that determines whether they can still remain to be an officer, do they still get to use that, or does it have to be guilty of a crime? Because currently it's misdemeanor or felony. So I'm just trying to figure out how the discipline side of that works for the law enforcement officer.
So with regard to Post, which would be the licensing agency, they don't care whether it's a misdemeanor or a felony. If it is a crime that involves breach of the public trust, if it's a theft crime, it's a crime that it affects their ability to serve the public trust, Post has the authority for any crime to withdraw, suspend, or terminate their ability to be a law enforcement officer in the state of Georgia.
Okay. All right, thank you.
Yes, sir.
All right, any other questions from members? I don't see any, but I have actually Chairman Smith. Oh.
All right. Just a quick question.
Yes, sir.
The state's been around a long time. Why do we need this now? Like, what has happened? Is there case law that's come down that's unfavorable? Because generally when you show up, you know, there's some case law that, you know, we got to address, as it is with anybody else.
Yes, sir.
But why now has this become an issue? Because, like, I always get this feeling in my, you know, it's not a burr under my saddle, but something shifted.
No, I can understand. It's a reasonable question. So first of all, in 1994, there's a case called State versus Tullis, and I can give the committee the quote. It's 213 Georgia Appeals 581, 213 Georgia Appeals 581, and I have a copy I can give the chairman, that looked at this exact issue and said, so if you have a public official, and they actually use two examples, who gets a speeding ticket or catches one trout over the creel limit, that's a misdemeanor. Should they be charged with violation of oath of office? And the Court of Appeals said no, that would be an unfair result. What has happened, very similar to the ethics that lawyers have, we have absolute must-dos and then we have aspirations. And the oaths that are being signed by officers, I have seen some of them that are 2 pages. They have references to multiple different organization ethics and oaths that could change. Some of them don't even know what they are. They've just been in there for years. And then in addition, a lot of them have a clause that say we will abide by the policies and procedures of the agency. So specifically, Mr. Chairman, we have had officers charged with a violation of oath of office, a felony, because they violated a report writing rule of their agency. Something that is not even a crime. So that's standardizing the oath is one thing. And then a breach of a public trust should disqualify someone for office, especially from law enforcement. And that's why we put the felony provision in here and said, please bring this to the level where the predicate is serious enough that this person should not serve the public trust anymore.
Okay. It seems like I've had this conversation with another individual this session. So thank you for the clarification.
Yes, sir.
Chairman Gunner.
Okay, there's misdemeanors and there's misdemeanors. Okay? So, I mean, if I'm a cop and I'm shoplifting small amounts and it only rises to a misdemeanor charge, you know, that doesn't count?
State versus Tullis was exactly that case, where an officer was convicted of shoplifting and they had charged him with violation of oath of office as well.
That wouldn't be a violation of oath of office?
It would not be a violation of oath of office.
You're kidding me.
The case is silent on whether or not it was on duty or not, but right now there's no nexus whatsoever with whether or not they're on duty or not.
And it shouldn't be. Whether they do it on duty or off doesn't matter. They're violating the law. I disagree with this bill. So.
All right. Any other questions? All right. So I'm going to go ahead and start calling, I guess, Lance. You signed up. Is Michael Callahan. Would you like to speak on it? Okay. We can make room for him.
Yeah, we can just, if you want to take the felony out of
Representative Seaball. Can we make room for him real quick? Good afternoon. If you can say your name and who you're with.
Good afternoon, Chairman. My name is Mike Callahan. I'm the president of the Georgia Fraternal Order of Police, representing our approximate 8,000 members here today. We stand in favor of this legislation. Some of the questions that were raised earlier, the remedy for this particular case would not be charging the officer with a felony, but the officer could be fired. He could be terminated for committing a crime. This bill seeks to protect officers from making a mistake, a misdemeanor violation, and having a DA or district attorney turning that into a felony. I think that's just giving us a fair playing field with everybody else. We're not trying to protect bad actors. Nobody in our profession wants to protect bad actors, but we also don't think that if you get in a traffic accident or if you get a ticket for driving too fast, that somebody, if they wish to, could use that as a felony against you. So we support this legislation, and we thank Representative Seaball for championing it for us.
Thank you. You have one question, Chairman Gunner.
Don't you agree that this lowers the standards for certified officers?
No, sir. I don't think it changes standards
We
at
can
all.
allow them to commit misdemeanors and...
Well, you're not allowing them to commit crimes. I mean, there's still repercussions to those violations. It's just that if a normal citizen commits a misdemeanor, that's a misdemeanor. It doesn't get turned into a felony.
Yeah, but these are people that carry out the law, enforce the law.
Yes, sir.
And we're just saying it's okay for them to commit misdemeanors.
No, sir. What we're saying is that a misdemeanor shouldn't be turned into a felony just because they're a police officer. There's still repercussions. They can still be terminated. Post can still revoke their certification that would remove them from the profession.
Okay. Of course, I disagree.
Yes, sir.
I hold them to a higher standard.
Yes, sir.
All right. Representative Panish?
This is kind of a new area for me, so I want to make it sure I understand. Have you seen an officer who committed a traffic violation, which is technically a misdemeanor in Georgia, been charged with a felony because of violation of oath?
Yes.
Like not a DUI, but a traffic.
VH2, vehicular homicide in the second degree, where somebody caused the death, would be a misdemeanor for anyone else.
Right.
But it was elevated, and they were also charged with violation of oath of office because they were a law enforcement officer.
Okay. Were they on duty?
Public official.
Were they on duty at the time? Okay. Thank you.
All right. Thank you. All right. Those are the only people that signed up, and we're going to thank you so much. Thank you. Do you, Representative Seaball, I'll give you the last word if you have any additional comments.
No, if there's no more questions, I think we're done.
We're going to go ahead and keep it a hearing only for
Okay.
today. Thank you
Thank
so
you.
much. All right, next, HB 237, Representative Chairman Carpenter. Okay, so
Thank you so much for having me again. It's like the
thank you.
phoenix. We've risen from the ashes.
okay,
I
we
heard we had a
are.
kumbaya moment, and I'm just glad to be a part of it.
Thank you. I don't know what that means. Okay, we have two different versions in our folder. Can you tell us the LC number you're going by?
The LC that I picked up right over here is LC 481534S. Is that what you see?
We have, that's one of them. Okay.
I don't know. I haven't seen the other one, so. Oh, well, we don't
Okay.
want that one. We know how folks feel about the original one, so we'd much rather have this one. This has got a few more extra check marks on it, so we appreciate it. I think this substitute comes before you as a negotiation between people on both sides of the issue. We addressed some evidence issues on 924. It was switched to preponderance of evidence. I think the chairman to my left here spoke of the bar being too high in the last hearing. We also changed 25 so that it says the defendant adopted the literal meaning of the work as the defendant's own thought or statement. So I think that gives a little bit of clarification to the judge in that regard, because it seems like the last time point number one was a little going to be hard to prove, and I think this is a little easier to prove. And then number two says the specific fact patterns indicate that the creative and artistic expression refers to the specific facts of the crime alleged. So obviously, if you're singing a song about robbing somebody, and you're in a homicide trial that doesn't play over. So not to use those lyrics against you, if you will. And I think that's reasonable. The other piece, line 30 through 32, is when they do admit expression of to evidence, they will be careful to apply redactions, etc., so that it's presented in the least prejudicial, thank you, means of presenting the creative and artistic expression. So I think it does. Obviously, the bill, I think y'all have done a good job getting it to a place where folks can live with. I think it's still important that we allow our creatives to be creative and not use it against them in a court of law unless proven beforehand, so that the jury is not tainted. And I will stand for any questions, and I appreciate your work on this legislation.
Thank you. Any questions from members? And thank you, Chairman, I know we heard this before, and thank you for working with us on some of the language here. We have, actually, Representative Roberts has a quick question.
I do have one question.
Okay.
I didn't notice it the first time around, but I understand the gang signs. What is it about tattoos? Why is
I forgot to mention the gangs. We actually added that language in.
But it's not tattoos of gang signs. It's any tattoos are not considered art?
No, I think it might just, I don't really understand the conversation of tattoos. This happened last year, to be real honest with you. I'm sure someone in the audience can speak to tattoos and being able to use them in a court of law. I don't know.
Art too,
I'm sure it's not a butterfly tattoo. I can assure you. Or a tribal band. That's probably not it. It's probably something a little more larger than that. So maybe gang relation signs, etc. Tattoos. As a man with no tattoos, I have no comment.
All right. Any other questions? I don't see any, but I've got one. D.A. Cranford signed up to speak.
Are we
Come
feeling
on
better
up.
about it? If you're not feeling better about it. There you go. That's good. Good looking fella here. Come on in here.
Good to see you again.
Yes, sir. Hope to never see you in the courtroom.
You seem very law-abiding to me. So.
I mean, if after the judge just laid the gauntlet down, I better not get a speeding ticket on the way home. I might get a felony. I'm nervous.
All right. D.A. Cranford, go ahead.
Yeah, so Herb Cranford, DA in the Coweta circuit. To start off, I'm still opposed to the bill because, like I said last time, I think our current law addresses this, and it allows a judge to consider, the relevance. And under 403, there's always going to be an assessment of, does the undue prejudice substantially outweigh the probative value? So that's still my perspective, and I think the perspective of Georgia's district attorneys based on how we voted about this. But I will say, this is a way better version than the last version. So I don't want to let you all think I agree with the need for this, but it's way better. A lot of it was addressed, about the things I testified about last time. To try to provide maybe a little more clarity to the line added at 15, it's got a reference to tattoos and hand signs. I spoke about that last time, and if you go to 1615.3 in the code, it defined criminal street gang, and what I was referencing was the second sentence of 1615.3. The definition of criminal street gang is the existence of such organization, association, or group of individuals associated in fact may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to activities, customs, or behaviors. So that's what I was referencing when I said 1615.3 already kind of speaks to, what could be used to identify somebody associating with a criminal street gang. So happy to take any questions, but I just, as much as I think it is a improved bill, again, I think our evidence code covers this issue as is, and I think we made a real point to adopt the federal rules of evidence, and a lot of work was put into that in 2012 or 13. And I think the federal government has yet to go down this road. And I think on this issue, I would give some deference to what Congress has done in studying the evidence code.
All right, you have a few questions, Judge Gunner.
Let me pull the statute.
Would this bill be a almost perfect bill if lines 15 and 16 were gone?
It would let me get to 15 and 16.
Sitting in front of you.
Oh, okay, thanks. So if we did away with the reference of, yeah, I mean, in texting with some other DAs, part of the discussion we were having was, what if a gang member did this or that, and it gets into the weeds pretty easily. So, I think that is a complicating thing.
So if it's out, it's a better bill? Even better than what it is now?
This thing is so good.
I'm trying to.
So good.
It would certainly be clearer. I don't know if I would say it's better.
Okay.
Yeah.
Good call.
Fair enough.
Yeah,
I know. Shall not include.
Do I need to sharpen
Actually,
my crayons?
I think Chairman Gunner would argue that this bill would be so much better if it was watered up and thrown in the trash can. That's the feeling I get.
I mean,
Chairman Smith.
I'm sorry I jumped the gun on it. Do I need to sharpen my crayons here? And I'm good if I do. It exempts those hand signs. That's what that language conveys. I mean, if I need to go get something other than Crayola, y'all tell me, but, I mean, why is it a problem being in that? I mean, what's the trouble with the language?
Because you can't use that.
I don't read it that way. I see that as, that's not considered artistic expression. A gang sign's not. I mean,
That's how I read it too.
I just.
So I read it, and I think this is, so that's the definition section. So creative or artistic expression. And creative or artistic expression, based on how it's written, does not include hand signs, tattoos. And so therefore, when we say, so that evidence would be admissible. Are we all on the same page? And I think that's why we had included the tattoo. I think you had some conversations about that. So because the
tattoo was in there on the first one.
prosecutor, correct.
There was some concern that the street gang language that was put in the code a few years ago with the governor's bill had already addressed that issue, so we needed to make sure it was comparable.
So hand signs, tattoos, hand signs indicating criminal street gang and tattoos could be used as evidence.
And if I may.
So therefore, Judge Gunner, you saying us taking it out, I wouldn't think that the DAs would want to take that out. Is that correct?
Yeah, I think
you would want to be able to use those.
Yeah, so by saying it's less than clear yet, we would like to be able to use those, and I think I understand the interpretation that we wouldn't have to go through this statute regarding tattoos or hand signs. The discussion I've been having with some other DAs is you could think of a lot of things, some of them terrible. Like, for example, somebody engages in a sex act, and if it's recorded, to a, soundtrack or something, would we have to go through this statute because it's arguably expression? I mean, there's just, you know, like I understand like this is primarily, as I understand it, about songs and things like that, but that's what's, you know, a concern about this is being artistically expressive could be attributed to a whole lot of stuff. And then we're traveling through this statute, whereas the code as it exists, I think, addresses it.
And you, and with that example, do you not believe that that would go towards the overcoming? You don't think you think there's going to be an issue with overcoming that presumption and lines essentially 25 through 29?
Yeah, I mean, you know, and I'm not trying to be difficult, but, you know, it'd be easy to attribute artistic expression to a lot of stuff, and then we're traveling through this new code section that kind of sits now on top of the rest of the rules of evidence, that just because somebody can articulate an argument that this is some kind of expressive behavior, we're now having to go through a whole other litmus test.
All right, Judge Gunner, you want to wait?
I don't mind including.
Judge Gunner.
I don't mind including everybody in on the conversation we're having over here, but it just seems to me that this is a do not use for creative or artistic expression, but that might be what is relevant in the case. You've got it under 1615 whatever. I'm not finding it in 3, it's the definition section, but how you use it, you know, it just seems to conflict with what's in the code already, with the exclusion here of those. That's what I'm worried about. I see a conflict here. And I can see a defense attorney really confusing things with that. You guys are good.
Representative Roberts.
I guess I want to go back to your example because I'm trying to understand. I thought this is, you can't use this evidence to prove that a crime was done. If I'm raped to a soundtrack, the crime is happening. That's not what we're trying to do here. We're trying to prevent a soundtrack that talks about raping me, but I was never raped, so why would we hold that? Does that make sense? I don't know.
Yeah, I mean, I think the hypotheticals we're all thinking about is the second one you gave, where we've charged somebody with rape and we think they've done, you know, a country song about raping somebody that, you know, seems like the same victim that we're trying to get justice for. But, you know,
But wouldn't that meet those 3 benchmarks if it did? If I was raped, then you would go to that evidence because it would. That's the whole point, is it has to connect. Am I missing something?
Yeah, but I mean, imagine if, you know, a lot of the facts are similar, such as it's a female that was raped under the age of 18, but they describe a different name or a different ethnicity or something. You know, like it wouldn't be hard to craft your expression as being a little bit different, and then do we fail under this statute? Whereas now, you know, a judge is assessing, you know, is there probative value to this that is not substantially outweighed by undue prejudice? And then the jury is left to decide, when he's singing this country song about this rape, is he talking about this actual rape they've accused him of?
What if you change specific to substantial?
I mean, that'd be better, you know, I mean, and
I mean, if the name's off, then you can still say it's substantially the same fact pattern.
yeah, I mean, that would be better than the current language. And I think,
I hope I'm not getting in trouble with this suggestion, sorry.
I mean, and that kind of just highlights the point. I think that, you know, I could probably sit here and come up with a whole bunch of hypotheticals that eat away at the language of this, and then we're back to the long, well-considered evidence code that we adopted from the federal government that I think handles these situations well. And I'd rather, have the jury decide if this song is in reference to the crime being committed. Where DAs go wrong is the hypothetical that was given earlier where, we're prosecuting a rape and somebody wants to admit a song about a robbery that has nothing to do with this.
Isn't that the point of this bill, is that you don't want someone being prejudiced by evidence coming in that's unrelated? That's
Right.
the whole point of this, I think.
Well, I think, I would say, yeah, my view is under the current evidence code, that scenario, that evidence should be excluded from trial. Like, I think the current law addresses that.
Yeah.
All right, any other questions for Mr. Cranford? Thank you.
All right, thank you.
There we go. You can't sit down here and not talk for a long time. Lawyers, I swear. This thing was sliding down. Everything was looking so nice and pretty, and then these darn lawyers got involved, I tell you.
Any other, anybody else who wants to testify to this? I don't think there's anybody else signed up. Chairman, are there other states who have enacted something similar?
Yep. There's Louisiana, California. I mean, there's a lot of artists in California there. They don't. Hey, the judges don't speed in California either, I hear. Louisiana. Yeah, and there'll be more on the way. This is a big. I mean, it's at the end of the day, this issue is going like this. So I think it's important. We've got a dynamic music industry in the state of Georgia, arts and creative, also film, etc. But really, from a music standpoint, it's important to show our folks that we support our creatives and allow them to be creative. So I wouldn't be surprised if language like this doesn't show up in Tennessee pretty soon, Florida, etc.
I like to see what's been, I haven't had a chance to look at the other states, but maybe look at that also.
Yeah, sure.
While
I like
we
to
go
be.
through that.
I like to be out in front sometimes, though. I mean, real leadership, you get out there in front sometimes. You don't wait for other people to jump out there. So.
Yes, sir.
Some of us are trailblazers.
All right. What's the will of the committee?
Motion to pass.
All right. We have a motion. Do we have a second? Second. Any discussion? All right. All those in favor of HB 237 LC 481534S, say aye. Those opposed, same sign. All right, it passes.
Thank you. Appreciate your work on this. I'm sure we'll continue to have these conversations.
Yes, please.
It's always a pleasure to watch you guys work.
Thank you.
I know. I heard you.
That's not a no.
Chairman Prince, thank you for waiting. You know how long judiciary takes. Thank you for being patient.
Man, I had no idea. Following this guy.
All right, we have HB 483.
Yes, thank you, Madam Chair and committee members. I bring you House Bill 483, LC 481484. You've seen this before. You came to your committee last year, but in House Bill 46, dealt with utility workers basically, and we're just adding to that code enforcement officers. Section 1 basically covers the definition of what a code enforcement officer is, and then adds it to part of being a public safety officer. The rest of the information, sections 2, 3, 4, 5, and 6 just talks about more the penalty from the assault phase to the battery, and that's basically what the bill does. It just really adds code enforcement officers in there with utility workers and all those that have to go out and actually enforce codes where sometimes they may not be welcome. Subject to your questions.
Okay. Thank you, Chairman. I do have a question. In lines 18, 19, you added Inspector of Code Enforcement to the
Public safety.
to the definition of public safety officer. I'm just, and maybe maybe you will, but would that change would that affect any other sections where we're talking about public safety officers? Because I would think at a public safety officer, they have more, what's the word I'm looking for? They have more, like law enforcement officers, classes they have to take in order for them to become public safety officers versus a code enforcement office inspector. So that's one, I think that's one part where we're basically putting them in as a public safety officer that I'm a little worried about. Do you know?
No, I do not know the
Okay.
answer to that, but I do know that they are trained to what they have to go out and actually enforce those types of things. But that's where I guess lead counsel sort of led me into adding. That's where she felt it should have fell in.
Okay. Representative Roberts?
Yes. Thank you, Chairman Prince, for bringing this bill. I actually was on a town hall last night, and one of my listeners brought up that they were in full support of this. So it must be something that is occurring when they're going out on sites to inspect. And
yes.
So I support the bill.
Chairman Smith?
I mean, I would support trying to make it consistent across our code sections. I think that would be something that we could work on. I've got one out in my area that he acts gung-ho. You thought he was a high sheriff. So, you know, I could say that I just thoroughly vet that. They're good code enforcement officers, by the way. But I mean, you know, really, I mean, I could understand. I can see the plight that the gentleman from Augusta has brought to us. I mean, it's almost like DNR. People's not really going to be too happy to see you show up.
Right.
There's not a good warm and fuzzy feeling. So I could understand the plight there. So I think this is a small fix that could be made just to make sure we have the consistency.
Thank you, Chairman.
Thank you.
All right, any other questions? I don't see any. I know, Gactel, do you have a comment on that part? If you don't mind, Chairman, I'm gonna.
We're just realizing along with you and wondering, agreeing that the concern would be any other time that 16.5.19.9 is cross-referenced, we will be pulling code enforcement officers in, and I just don't know I was just going to search to find all those cross-references.
Okay.
And without knowing what the purpose of wanting the code enforcement officer to be considered a public safety officer, like perhaps there is a place where they're trying to allow them to have that be included, but with, you know, we don't have to put all of the details in the bill.
So I want to make sure that we're doing what, Chairman, you're intending to do, which I think is good, but not touching other sections that you may not intend to.
Roger.
By including that in the definition. Chairman Smith, do you have a
Chairman Prince, do you know if code enforcement officers are post-certified?
I don't think they are. No, they're not.
Okay.
Okay. So That's the only thing, Chairman. I think that we probably will just need to look at that if you're open to that, and
I'm
we
definitely open to if we need to strike that in that section and have it amended. I mean, you guys can do that, I think. And
I would like
sure
to
what else
go
we
ahead
can
and try to see where, kind of go through the code sections and see, and Gactyl, if you can help us with that eventually, and see whether or not we need to just take that out and still be able to do, what you intend to do, and or if we need to go ahead and maybe do other amendments to make sure that it's all aligned. Any other questions from members? All right. What's the will of the committee? All right, we have a motion and a second. Any discussion? All right, those in favor of HB 483, LC 481484, say aye. Those opposed, same sign. All right, Chairman, it passes. If we can, we'll look at that and clean that up. Thank you so much.
Thank you. Thank you for your time.
All right, and last bill is HB 53535, Chairman Smith. Thank you for waiting.
Of course. We like to accommodate everybody else before. I've been in committees where the chairman's bill was the first one taken up, and I'm like, that's not good. But anyways, I digress. I bring to the members of this great committee House Bill 535. This is in response to a case by the name of Kellum that was reached by the Court of Appeals. So I'm one of those guilty of bringing case law. Has directed us for a change, so I'm not just seeming like I'm picking on people. I myself do it. This bill would fix a Court of Appeals decision that has caused a little bit of confusion and inconsistency in how time served is calculated in our probation revocation cases. In almost all contexts, if a person is sitting in jail awaiting adjudication of a case, Georgia law dictates that their time sitting in jail counts as time served if they're sentenced to more jail or prison time. However, this standard way of calculating time served does not apply to people awaiting a probation revocation hearing, which has led to confusion, inconsistency, and sentences that stretch longer than courts would intend. And this inconsistency was caused by a 2023 decision in Kellum that held that time sitting in jail awaiting a probation revocation hearing only counts as time served for purposes of the overall length of a probation sentence. Also, in that holding, it said that if probation is revoked, time in jail does not count as time served for any carceral sentence. For many, this has resulted in what would loosely be called an artificially long sentence due to simply how time is counted. Judges will issue orders thinking they're sentencing someone to one sentence, but GDC must then have to calculate the time served in an unintuitive manner that ultimately leads to longer sentences than judges intended. Not trying to throw any shade at GDC, they're just having to go off of the best information they can. For example, let's say someone sat in jail for 6 months waiting for the adjudication of a probation revocation hearing. And furthermore, let's say that that probation is indeed revoked and the judge wants to sentence them to 1 year total prison time. Traditionally, a judge would order 1 year in prison with 6 months time served. The individual would then serve 1 total year behind bars. But the Kellum decision now forces GDC to disregard those 6 months in jail. So even if an order states 1 year counting 6 months time served, GDC must disregard the time served portion of the order and enforce a full year sentence in prison from the date of that order. This means the individual ends up serving 18 months in prison instead of 12. This bill provides a very simple fix. Count time served for probation revocation cases in the same way as any other case. This is how courts counted time served for years before the Court of Appeals decision created the legal fiction that time in jail only counts as time on probation for purposes of time served calculations. Thankfully, DCS has been a great partner, and I want to give y'all a shout out. Y'all have been a great asset to this committee and personally to me as the chairman, so I appreciate y'all They're good with the language. We've included a clause at their request that ensures that people will not get credit for time served if their sentence is told due to the individual's reporting issues. And having handled several of these cases myself, it's tough. Usually by the time I get on a case, a lot of times, more often than not, the individual's been sitting there a long time. And, in their mind, and rightfully so, it's time sat for naught. And so, this cleans that up. And that's the bill.
All right, thank you, Chairman. Any questions from members? I don't see any. I don't see anybody signed up to speak. All right, motion in a second. Any discussion? All right, those in favor of HB 535 LC 481478, say aye. Those opposed, same sign. All right, it passes, Chairman. And we are adjourned. We're adjourned. Thank y'all. Thank you.